Hello, ladies and gentlemen. Welcome to Donna Just Being Real. My channel is all about dating, love, relationships, and toxic relationship advice channel. Yes, we're back into this again. Sewer rat. Yep. Back to sewer rat. Darrell Brooks. You know that monster that drove into that parade and killed 6 people and injured several and had the nerves to be a clown in the court. Thought he was smarter and he was above everybody else. He thought he was smarter than the judge. He thought he was smarter than the jury. He thought he was smarter than prosecution. Everybody. All he did was gaslight everybody in there. He was a clown, but at the end of the day, ha ha, you're going to prison. All right, so now he's back in court. So why is he back in court? We're going to get into this one. It's because of restitution. Yes, restitution. So we're going to watch this video. And the topic is Sewer Rat Darrell Brooks back in court restitution hearing. And what you do is you make sure you hit that like button, share the video on your social media, and also share your thoughts and opinions in the comment section. Let me know what you think. And also, if you need to reach out to me for a viewer's request or in dating, love, relationship, you need coaching and anything like that, or just need to talk to me about anything, you can find my email address inside the description. Okay, ladies and gentlemen? So, all right, let's get it. It might be times I might pause just for a second to share my thoughts. But don't forget, you definitely share your thoughts. All right, so back to Sewer Rat. He's just a piece of work. See, these narcs and sociopaths, they never seem to go away. They don't. They really don't. But he can act like the biggest clown that he want. He think he's smarter than everybody else, but he's not. And I think he's still probably going back to court with the Erica Patterson thing. I'm not too sure when it's supposed to be. I think in June or something like that. I'm not quite sure, so don't quote me on it. All right, so ladies and gentlemen, let's get it.
Today to address the state's request for additional restitution. That letter was filed back on November 30th of 2020.
Do you see this clown? He look like he ain't getting no sun at all. Just look at him, just sitting there. What happened to your rap career, sir? What happened to it? It's over, huh? What were you? Late 30s, early 40s, want to be a rapper? Really? 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 All right, let's get back to it, ladies and gentlemen. Resume.
The court had given Mr. Brooks until January 3 to file an objection, and a response was filed that the court interpreted as an objection. Since that time, Attorney Covey has been appointed to represent Mr. Brooks in the appellate process, but you are appearing here today, and we are thankful for that. And so the matter was put on. Obviously, it's outside some of the time limits, but I would note the original request was made timely, and frankly, it was due to the
Go for Grubhub.
court's calendar. Originally, I had been scheduled to be in a 5-week trial starting February 13th. And then that was delayed by 2 weeks, and ultimately that trial was adjourned. And so that was the reason for the hearing being scheduled on today's date. So for now, I don't anticipate your client having to talk. I can just hear background, so I'm just going to mute it, and if we need to talk to him, we'll unmute. There'll be a 30-second delay unless he has the device there, but to unmute. But in any event, I think I've accurately stated kind of the timing of the requests. As I understand, the additional paperwork that was filed as recently as April 12th, and I trust you've seen that, Attorney Covey?
Judge, yes, I did see, I think you're talking about document 566.
Yes.
I have that right in my hand.
All right, and so does the state have a grand total for additional restitution the state is seeking?
So to be clear, Your Honor, on the document, that's one that's titled, well, the first thing is crime victim compensation. Okay, thank you.
Yes, I just couldn't tell if that, I didn't do the math, if that's.
Yes, I wanted to be clear on that. So at the bottom it notes you've already ordered sum of 124,220.65 to crime victim compensation.
Yes.
The grand total that's listed at the top of 134,466.85 encompasses that 124. So this is not in addition to, okay? So our request for crime victim compensation is 134,466.85. For Wilbur and Associates or Hartford Insurance, total request is $108,164.61. Optum subrogation, $118, $805.62. Progressive Insurance, $10,000 for victim GGG, and Progressive Insurance, $104,662.64 for victim Q.
All right, and I believe your letter of November 29 indicates the additional amounts that you're seeking. And then this document really totals things up.
Yes, it does. And at the bottom, already ordered the EMC insurance for Waukesha School District. That was already ordered, and there's no update to that number, so that number can remain as fixed.
Basically, Sorat, you're not getting anything. They're going to strip you for whatever you have, which you don't have anything. You're dusty. You're a bum. You ain't got nothing to offer. You don't have nothing. But they just making sure that you don't. Just in case you decide to, do a book, make a movie, something like that. You won't get it. Not at all. Yep, resume.
I'm just going to do a quick calculation to determine the additional amount to crime victim compensation the state is seeking. Looks like that's $10,246.20.
I'm sorry, could you repeat that number?
Assuming I hit the keys on my calculator
okay.
correctly, it's the difference between the 134 plus minus the 124, and that's $10,246.20.
Yes, we agree with that.
All right, and then the additional other amounts to other individuals, namely insurance companies, are really those four amounts that are listed in near the bottom of this document to Hartford Insurance, the Optum, and Progressive for two different victims.
Yes, correct.
All right, is that your understanding of what was being requested, Attorney Covey?
Judge, it clarifies things. I had thought that the state was asking for an additional, the full 134,466.85 in addition to the 124. So my original number, I thought was just north of 476,000, but it seems like it's closer to about 350,000, give or take. I'm using round numbers because I don't have a calculator with me.
Understood. It's my understanding from the document that you filed on behalf of Mr. Brooks that Mr. Brooks is not contesting the loss that was suffered, but rather his ability to pay.
Judge, that is correct. I'm not asking for, at least for anything to date, anybody to present extra documentation as to the accuracy of these numbers. It's just on his earning ability and lack of funds.
And was that the state's understanding as well?
Yes.
I know in the filing from Attorney Covey, I don't recall if it was the letter or the actual motion to deny, there's a claim that Mr. Brooks is indigent based upon his incarceration. Is the state going to take any issue with that?
We're agreeing to that fact, Your Honor. We've reached a stipulation with Attorney Covey that recognizes Mr. Brooks, to our knowledge, is indigent at this time, and that his future earning capacity would be limited to prison wages.
And that's an agreeable stipulation.
I can't stop laughing. Just look at him. Look at this clown. He's trying to act like he's so smart. He's so intelligent. You're not. You're a sorry piece of crap. You are. You, your mama saw a rat, and grandma saw a rat. Yeah, I said it. The whole family. Resume.
Stipulation to the defense.
Judge, we reached that agreement yesterday. Absolutely, I suggested it.
I don't want to be presumptuous, but I know the last time the court addressed restitution, the state was requesting really an order related to an escrow account. Should there be future payouts or earnings by Mr. Brooks, will you be making the same request?
Yes, and I noted that is in the original judgment of conviction that was filed by the court on November 17th of 2022. You had made that order and that finding at the time of sentencing, and you had also indicated restitution costs and surcharges and fees to be collected from prison monies pursuant to statutory authority. And so
I said, let me just put up the little family tree. You got saw rat at the bottom right. You have Mama saw rat on the bottom left. And Grandma saw rat up on top. Resume.
we're going to ask both of those orders remain in place.
Will your client have any objection to that?
If there's additional restitution, I don't object to the escrow account.
That would be for monies paid to Mr. Brooks, not a restitution, not a escrow account beyond that. Under 949-165.
I'm sorry, Counselor, if I may, just for 1 second. Oh, yeah. I get it now. Okay, thank you so much. Judge, counsel explained to me briefly what she was getting at. I don't have any objection to that.
All right. Then it seems to me there's really just some legal arguments as to whether I should order the additional restitution.
Yes, Judge.
The stipulation then would put us in a position where Mr. Brooks does not need to testify. That's my understanding, and that would be how I would proceed. Anyone see that any differently? Attorney Opper?
We do not.
Judge, that was the reason why I suggested the stipulation.
All right, thank you. Then, since it is the state's request for additional restitution, I'll hear from the state.
Thank you, Judge. Your Honor, we are asking this court to order restitution in the full amount as proposed in the document we filed yesterday. I think you said it was 566.
Yes, Counselor. Here.
Thank you. I'm sorry. I just don't know the document number.
Yes, it is document number 566.
Judge, we certainly understand ability to pay as one of the factors that the court is to consider here, but we'd like to highlight a couple of things. First of all, one of the goals of restitution is to rehabilitate the defendant. We think that is an important goal in this case, noting the damage that was inflicted by this defendant to multiple victims. We would note that most of the monies, or at least a majority of the monies, came from the Crime Victim Compensation Fund, which really is funded by taxpayers. It's a state fund, and that I'm glad to see on this list there's no individual victims. That the desire for the public to have those monies repaid to the CVC if appropriate. As far as the insurance companies, the same, Your Honor. While I understand they operate as a for-profit business, these were substantial expenses that they had to cover for their insured, for their clients, and a direct result of the defendant's conduct and the significant injuries that several of these victims suffered as a result of Mr. Brooks' behavior. So we do believe that it's both fair and appropriate for the court to order the whole amount, notwithstanding that limitation. The reality is that perhaps this will never be achieved by Mr. Brooks in his lifetime on prison wages, but it would serve a rehabilitative purpose, because should he ever receive employment within the prison system and a wage, albeit minimum, it would be a reminder to him and aid in his rehabilitation, that for whatever monies he earns in the prison, a portion of it does go back to the Crime Victim Compensation Fund. And the other thing is, Your Honor, of course, we don't know if an escrow account would ever be needed under 949.165, but I think we can make a reasonable observation here that there is potential for Mr. Brooks to obtain money in the form of payment to sell his story, to engage in a book deal or a movie offer or whatever it is. We know that this case garnered international attention. It's not
They making sure, Sorat, that you don't get a dime for what you did to these people. See, these are the 6 victims that you murdered. You took your mama's vehicle. Yep. You took your mama's vehicle and ran right through the parade. And there's so many people that's injured as we speaking right now, going through PTSD, traumatized kids are traumatized. Oh yeah, people dealing with a lifetime of being traumatized because of you. And let's talk about your nephew. You remember your nephew that you shot at? Your twin sister's son, your deceased twin sister? Wow, this is how you do your nephew? You shot at him for a cell phone? Oh, I know he's happy your ass is out the, excuse my language. Let me rephrase. I know he's happy that you are out of the house. I don't even know why Mama Surratt even let you stay in the house. All right, let's get back to it.
beyond the realm of possibility that someone may at some point offer him some funds or some sum of money to share his perspective on this case. And so I would hate for this court to, set $100,000 today and then tomorrow he gets a $500,000 book deal. That would be offensive, I think, and go beyond the scope and the purpose of restitution. So for that reason, Your Honor, even noting his current limited ability to pay, we feel it's appropriate that you order the full amount as requested. Thank you.
Here's one thing you need to do before buying anything online.
To the defense, I don't want to make any assumptions, but it's my recollection.
Erica Patterson, you remember? The mother of your child, and you took your mother's vehicle to run her over. I think it was because you didn't want to she didn't want to give you some money or something like that, or you was mad because you went to jail, whatever it was. But you took your mother's car and tried to run this woman over. Well, you did hit her. The mother of your child. Thank God you will never be able to walk the streets again. Resume.
Probably during the sentencing, maybe even during some of the witnesses, or even during maybe discussion related to jury selection. Obviously, the community had set up a fund.
Oh, I forgot to add. How old were you? You was messing with this minor? What was she, 15 years old? Oh, let's not forget that. You low-life piece of crap. You think you smart, right? But you're not. You're done. You're done. Resume.
for victims to seek reimbursement. It's my understanding that this restitution amount that's being requested would be larger. I don't know if it would be substantially larger if all losses were being requested by the state.
That's an accurate statement, Your Honor, and I think it's very fair to say it would have been substantially larger if it not had been for the generosity of individuals who contributed to those funds.
As I recall, were there millions in that fund at one point?
I believe that's accurate, yes, I've confirmed that.
All right, and then I had also heard, but I don't know if there's any truth to this, but that at one point Mr. Brooks himself may have demanded payment to talk to a news organization or some media outlet. Again, I don't want to make assumptions, but I had heard that at one point.
Attorney Wichow and I are, I've heard that as well, but I can't confirm that with any certainty, Your Honor.
All right, thank you. Then turning to you, Attorney Covey.
Thank you, Judge. Although I'm relatively new to the case, I can state, just from my review of the file so far, I haven't heard anything at all about anybody offering any kind of book deal or any kind of sums of money in any way, shape, or form to Mr. Brooks. I think it's the odds of Hollywood knocking down his door to give him lots of money for his life story, I think given the totality of the circumstances of this case.
So you have a point. We doubt that. But they just want to make sure, just in case if it does happen, he doesn't get a dime. So you just want to cover all tracks, all angles. You make sure he doesn't get anything. That's all. That's all. And this is great to make sure he doesn't, because you just never know. People find these lunatics like them to be so fascinating. You know, they want to make, they make money off of this. It's just sick. It's sick. It really is. But okay, let's get back to it.
I just think are so minuscule that I don't think that argument should be given much weight. I also couldn't imagine any of the media, whether it's a YouTube blogger or the people that are next door to this courtroom, offering Mr. Brooks any money for some kind of exclusive interview. I cannot foresee the future with 1,000% certainty, but I think the odds of that, again, are just exceptionally low. I appreciate the fact, Judge, that the state's stipulating that he's indigent. I think counsel mentioned minimum, and I just want to make sure that the court recognizes that we're not talking minimum wage as a legal $17, $18, $19 an hour for prison work. If he's offered work in any of the facilities that he's going to be serving time in, at best he'll be getting perhaps a few dimes an hour for janitorial work or cleaning up the kitchen. The type of wages that are earned by inmates in our correctional system, they're not used to save up lots of money. They're used to sometimes save up to buy a bag of Doritos or some deodorant or toiletries. That's essentially his earning capacity. If they let him work, perhaps $1 or $2 a day if he works the entire day. So that's the reality of what he's facing. Judge, counsel touched on this, and I appreciate her argument. Frankly, whether you order $50,000 or $500,000 or $5 million, it's very unlikely that Mr. Brooks would be able to pay even the smallest fraction of that. But this hearing still matters. This is not just a moot point or a moot exercise, because you do have the duty, Judge, to balance 5 sometimes competing factors as listed in Wisconsin Statute 973.2013. I mentioned it in my motion, and then, of course, the 5th factor was I sent a letter to the court about that yesterday. The 5 factors are the amount of loss suffered by any victim as a result of the crime considered at sentencing. 2, financial resources of the defendant. 3, the present and future earning ability of the defendant. 4, the needs and earning ability of the defendant's dependents. And 5, any other factor which the court deems appropriate. Judge, I'll go just a little bit out of order. on subsection 4 regarding Mr. Brooks' dependents, recognizing that he's currently serving multiple life sentences consecutive, realistically, he's not going to be able to support his dependents anyways. And so that factor isn't really on point for this hearing. On the first criteria, the amount of loss suffered from the victims, I'm not surprised that the totality could be in the millions of dollars. I'm sure it's an absolutely enormous amount. And you have that discretion to give that factor great weight. I concede that. But I also hope that you consider the next two factors as well, and they kind of go together. His earning ability and his current financial resources. I hope that gets great weight as well. He's had significant financial problems even before this case. I believe he qualified for a public defender from day one. If he were to testify, he would testify that he had no savings, no assets. He doesn't have any kind of inheritance coming down his way. Nobody owes him any kind of...
Please put out the violins for this sewer rat. We're supposed to feel sorry for him. I'd like to see some violins. Resume.
Of money. I don't think anybody would dispute those facts. If you add on another $500,000 or $350,000 to what he's already been ordered to pay, which is in excess of $171,000, then you are sending a message that the two factors, his poverty, his earnings abilities, just don't matter. And I hope that they should be considered. Finally, Judge, subsection number 5 is the catch-all section.
Did he consider these people's lives? Did he consider their lives? Did he have any respect for his twin sister's son? It's already hard enough he lost his mother. Very difficult. And as being the uncle, that was your job to step in. But nope, you shot at him because of a cell phone. This girl, she was a child, 15. You manipulated her and got her pregnant. Yep, they got the nerves on the stand to try to degrade her, like it's something wrong with her. No, my own fault was that she dealt with somebody like you, a sewer rat. Yep. Then you got this clan right here. All your life growing up, you got away with a lot. Everybody coddled you. Mama sewer rat, grandma sewer rat. Yep, Yep, violins for sewer rat. Darrell Brooks, violins. All right, let's get back to it.
Where you can consider any other factors which the court deems appropriate. I'm not sure if the amount of restitution in document 566 is the sum total of what might be requested in future restitution hearings. The law, there is case law that states that a request could be made well past the 90 days after the sentencing hearing. We could object to it, but a lot of courts have upheld those. And I believe just for the sake of judicial efficiency, since he cannot pay anyways, since he really couldn't raise more than a couple of dollars a month anyways, is it worth the court system's resources, our time, the court's time, the community's time, to have potential extra restitution hearings when the ability for him to pay anything is going to be minimal or nil? And Judge, I guess one last thing. I would respectfully disagree that this is about rehabilitation. Given the length of Mr. Brooks' sentence, I think this is just more additional punishment, adding extra zeros to the judgment of conviction for money that he owes. I recognize the gravity of the harm, and I mean no disrespect to anybody who suffered any injuries or the medical bills from this case. But given the totality of the circumstances, his multiple life sentences, I just don't think it makes sense to add on any additional.
People's medical bills. Yeah. As we speaking right now, people are struggling, probably trying to have to pay, that co-payment to get the medication, pay to go to physical therapy. Their insurance only covers a certain amount of physical therapy, but they need more. Or have to go to therapy. The children need to go to therapy because they traumatized for what they seen. That car just flew right by them and almost could have hit them. They traumatized. Probably scared to walk the streets. Nobody wants to go to parade. You think these kids ever want to go back to a parade again? I doubt it. Anything with a crowd, they'd be scared. Oh, mommy, daddy, car might come. So yeah, they have to go through therapy, physical therapy, time, money, loss. Probably going to work. Some people going back to work, but in so much pain because of what you did physically. But they have to go to work. They got to pay their bills, right? Nope. We don't have no sympathy for you. Not at all. No sympathy for you. Not at all. All right, let's get back to it.
No restitution. It's just more paperwork, potentially extra hearings for no really just purpose except to add extra numbers on the judgment of conviction. I'm happy to answer any questions you might have, Judge, and thank you.
All right, thank you. First of all, I do want to thank the parties again for the stipulation. I think that certainly has made this hearing one that is running quite smoothly, but also kept victims from having to testify again regarding the loss that they suffered, and even frankly, the representatives from crime victim compensation or the insurance companies related to this. I also appreciate the stipulation from the state regarding the indigency. I think that's a testament to both counsel here and their willingness to, look at this objectively and what the purpose of this hearing and what the court needs to do. It is true that the court does need to consider the statutory criteria in 973.20. That's been referenced by Attorney Covey, both orally here in court today and in his motion to deny restitution. There are 5 criteria, really, when you look at the statute: the amount of loss suffered by any victim as a result of a crime considered at sentencing, the financial resources of the defendant, the present and future earning ability of the defendant, the needs and earning ability of the defendant's dependents, and any other factors the court deems appropriate, really what we would call the catch-all. Obviously, this concerns a case where Mr. Brooks was convicted of dozens and dozens of crimes based upon conduct stemming from him driving an SUV through the Waukesha Christmas parade. There were 73 named victims, one of whom was the victim of the domestic abuse-related convictions, and then, of course, the 6 individuals who perished as a result of his conduct and the 68 others who were injured. There are family members that are represented by each of those victims as well. This was and remains a very significant crime that has and will have lifelong effects for not just Mr. Brooks, not just these victims, but the community as a whole. And the losses that were suffered apart from the death and the injuries is only in part represented by the dollar figures that have been requested by the state on behalf of the victims. And that's what prompted one of the questions to Attorney Opper is that there was, and I think perhaps, I don't know if it still has any money left in it, but we know that there was a fund set up by community members, really funded, I'm sure, if you were to look carefully, probably internationally, with millions of dollars that helped defray costs and the loss to many of the victims. There was testimony, whether during the trial or probably more at the sentencing, of individuals who did not have insurance and suffered out-of-pocket losses, and thankfully, the community stepped up. Crime victim compensation.
That's a great point you just brought up. There's a lot of people out here that don't have health insurance, and what they lost and what they going through out of pocket. And we're supposed to worry about you? You gotta be kidding me, Sewer Rat. Are you joking? You gotta be. Look at his ears. Don't he look like a sewer rat? Just look at the picture up on top, and look at him. Look at it. Look at the face, the nose, the chin, the ears. Look just like a rat. He looked like a true sewer rat. All right, let's get back to it.
Compensation stepped up, but it would have been significantly more in terms of the dollar amounts that the state is seeking, but for that fund that had been created and used to help the victims of Mr. Brooks's crimes. And so I think that's an important consideration for this court to consider. In addition to the type of loss that was suffered here, I mentioned this earlier, there was death, great bodily harm, certainly emotional and physical trauma, and because this involved a parade and Mr. Brooks driving through it, there's also that sense of security and safety in our community that he robbed not just the parade goers on that fateful day, but really the community, the state. I think anyone who's heard anything about this case would feel a real sense of security that was stolen by Mr. Brooks. I do think the state's argument on rehabilitation is a solid argument. The bottom line is Mr. Brooks completely minimized his conduct both during the trial and at sentencing. And it is important, if only symbolic, that while he is in prison for the rest of his life, that whatever meager sums he might make with a prison wage, that there be a reminder to him why there is this deduction from his monies, that his ability to go to the canteen or to buy some extra item that's not otherwise provided by the prison, that there be that reminder to him that he doesn't have even the full access to whatever money is on his account. Now, I'd remind everyone, the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies. And I think that's an appropriate cap. I also think it's important that this court consider that the vast majority, I shouldn't say vast majority, but a significant amount of the restitution is to crime victim compensation, which is a state fund, largely, if not all, funded by taxpayers. And even if there were some grants that are there from federal resources, which I imagine there might be, that's still taxpayer funded. And so I think that's another consideration for this court to look at and consider. Now, I do have to balance. I'll look at all the criteria. Obviously, significant amount of loss. That's criteria reflected in sub 13 sub A. Sub 13 sub B, the financial resources of the defendant. Clearly, they are extremely limited at this time. However, there is absolutely no doubt in my mind that the possibility exists for Mr. Brooks at some point in the future to possibly profit from a book deal, a made-for-TV movie, a movie, whatever it may be. Maybe it's just doing an interview or whatever the case may be. I don't think that can be ruled out, even if he is obviously the person who was convicted of that, but there was international attention. This court had Court TV in to stream the trial. This court has always streamed every hearing as it relates to this case, in part because of the number of victims, and I could not, I don't have a courtroom big enough in this county to hold all parties involved. Certainly during the trial, this courtroom was packed on a daily basis. And to say that the trial went viral, I think would be an understatement. And so all of that relates to, though, that catch-all factor and the possibility that Mr. Brooks could come into a sum of money at a later point in time because of the story that he could provide or tell on his own behalf. You need only look at Netflix to know that crime stories are incredibly, they're things people want to watch. People find them interesting. People want to know the why. They want to know the how. And it's certainly not just this case, but we've seen it, and not that that's been on Netflix or anything, but other cases have captured the attention. So I don't think it's beyond the, it's not an impossibility, let's say. It's, I think, a very real possibility that someone might produce something someday for more of a commercial or theatrical type purpose, even if it's a true crime type situation. And that it's possible that Mr. Brooks could profit from that. And that certainly is why at the time of sentencing, the court addressed the request by the state related to the escrow account. I think that's important to do that here. And so when I balance all of these things, when I consider the significant amount of the loss, the court's desire to hold Mr. Brooks accountable, and even if it's a small reminder with his prison monies, that does serve a very important rehabilitative role, because even though he's serving successive life sentences, we all hope that one day he truly is able to accept full responsibility for what he has done, not minimize his conduct, and so that this award of restitution in full, as the state has requested, is important. And I will grant the additional amounts as I.
Look at his sorry butt. Just look at him. He's mad. He's mad. You see, this is what I'm saying about with these sociopaths. They feel that they're entitled for everything. So he's mad at the judge, like, how could you do this to me? I'm entitled to it. What are you entitled? Well, these people right here, these 6 people was entitled to live their life. It's only God to make that call. It wasn't your call, right? Okay, he was entitled to, have respect from you as being his uncle, but you decide to shoot at him, right? Okay, she was entitled to have respect from you because you took advantage of her when she was 15 years old, and this is the mother of your child, right? And there's so many other people as we speaking right now that has been injured and they traumatized, like I said before. But you want to be up in this courtroom and you want to be mad at everybody? You're mad because you feel entitled? Poor you? You gotta be kidding me. You know what? You belong in the sewer with a bunch of rats. Yeah, I said it. And your family, too. Got the nerves. They spoiled you. Spoiled you. It made you grow up to think that you're entitled to everything. All right, let's get back to it. We're almost done, ladies and gentlemen. Just hang in there.
I indicated earlier, it's $10,246.20 to crime victim compensation. That total then to them for the judgment of conviction is $134,466.85. Then to Wilbur and Associates, which is Hartford Insurance, $108,000, $164.61. Optum Subrogation, $118,805.62. And then Progressive Insurance for victim GGG, $10,000, and Progressive Insurance for victim Q, $104,000. $1,662.64. That is, of course, on top of what the court had already ordered to EMC insurance of $47,193.29. So again, I'll grant the request of the state. We'll also include that it be payable out of any prison monies per state statute, and the court under 949.165 makes the additional amounts of restitution ordered today subject to the escrow account under that statute. Anything the state thinks I've overlooked as it relates to this?
No, Your Honor, thank you.
Anything the defense thinks I've overlooked as it relates to this?
Judge, I think I'm good. I'll just let Mr. Brooks know that I'll set up a phone call with them soon. If you could just wave your hand so I know that you heard that, sir.
Oh, and
Yeah,
I
he did.
forgot to state this at the beginning of the hearing, obviously.
Ooh, he mad, he mad, he mad. Ha, 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 ha. Resume.
It had made reference to the video conferencing. He's appearing through the Zoom platform through our technology. It's working. I can see him. You can see him. He's indicated twice now that he hears us. Clearly, the technology is working and it meets the minimum standards for video conferencing.
What happened? You don't have your boxes like last time. We was acting like a little spoiled brat, and you put all the boxes in front of you so nobody can see you. You mad? You don't have your boxes with you? Ha! Let's get back to it.
Conferencing, and given that there was no testimony that was taken today, too, was obviously very appropriate for him to appear that way. He has 20 days from today's date to appeal the decision of the court. I will, of course, make sure an amended judgment of conviction is done as quickly as possible, get that signed, and that will be uploaded to the e-filing system. All right, thank you, everyone. That does conclude our hearing today. Good luck.
Thank you, Judge.
Thank you, Judge.
Oh well, you will not be getting a dime. I love it. Look at him. He's mad. He mad. He mad. He mad. Oh well. You're gonna have to pay. With the little chump change that you're getting. Nothing. Nothing. All the little chump change that you have. But whatever. It is what it is. Alright, so ladies and gentlemen, thank you for being here and watching and everything. And make sure you leave some feedback. I'd like to know, what do you think of this whole thing? Let me know. And also, I will be following when he goes, to trial that's dealing with Erica Patterson. Yes, I will follow that. If it does go live, if it goes public, then I will follow it and everything. And I might also do another video with him and Erica Patterson on the stand. Dealing more about with the gaslighting. Like I said, my channel is a teaching channel. It's basically learn. We learn about, toxic behavior. To date smart, not thirsty to see the signs. So we might, revisit this one again. When I have some time, I'm going to upload something on this one. All right. So like I said, make sure you hit the like button, share your thoughts and opinions in the comment section. And also, if you like my commentary, subscribe and feel free to check out some of my past commentary and leave some feedback. All right. So adios, Surat. Good luck. Bye.